I'd like to ask both of our panelists for their key takeaways, which is really just one or 2 points that they want to leave you with. Alan, seeing as we heard from you first, do you want to give us some final thoughts from yourself?
Sure. I found the AmEx case to be quite disappointing, as you may gather. But I think in the long run, courts have a way of figuring out how to evolve antitrust law to achieve sensible results. And I'm guardedly optimistic that they'll do so in two-sided markets. And these are some of the most valuable, significant companies now in the modern economy. And it's hard to believe that they'll have some sort of antitrust immunity simply because they're two-sided and it's too complicated to figure out. I think that courts will find a way to come up with sensible results that constrain anti-competitive behavior under the antitrust laws.
Excellent. And Rob, some key takeaways from yourself.
Well, I fall back to the practical advice for the antitrust practitioners. And the first practical advice is to do a careful and thorough evaluation of whether or not you may be dealing with a two-sided market situation. Do a sort of risk analysis if you're on the plaintiff side. And what is the risk that this two-sided type of perspective is going to be accepted by a lower court in a particular situation? And then secondly, assuming that is the case, how would I potentially analyze a two-sided situation following the general framework laid out by the Supreme Court, and to carefully go through all of the aspects of an antitrust case, from market definition to market power to anti-competitive effects to damages, and if it's a class cert case, common impact, and to think through all of those issues and how they would play out potentially in a two-sided context.